Now, this conversation tonight has been growing for the past couple of years, and it's difficult to avoid this conversation if you've been opening a newspaper, turning on TV, or anywhere. We're talking about name, image, and likeness in college sports. We're looking forward to a topic that would appeal to both doctors and lawyers and anybody who's a fan of college sports. And we have some really top-notch. They are nationwide known for this topic tonight. So we have Professor David Weber of Creighton Law, and we have Tyler Seals of Smith Pauley Law Firm here tonight to give us the basics, give us more than the basics on NIL. So I'll turn it over to them. No, let's do.
All right, can you guys hear us all right?
Oh, those are for the audio, but
These are my.
yeah, the mics are mics.
All right, is this better? All right, well, welcome. Tyler and I are going to have a conversation, hopefully with all of you, about NIL tonight. This is a fascinating area, and if you watch the news, it's in the news every single day. As they've said, even today, there was a vote by Dartmouth men's basketball team to unionize. So they are going to be the first unionized college sports team in the country. That's still pending an appeal for the underlying order that allowed the vote. But we'll talk about a bunch of different issues that are ranging around the country. But I think, Tyler, maybe we start off with what is NIL and what does that mean?
Sure. Thank you all for coming out tonight. It's a pleasure to be here and speak with my former professor, now apparently my colleague in the very small world of the NIL space. Oh, sorry, it's not really picking up later. You guys hear me? So yeah, thank you all for being here. So NIL, and just a little bit of background on me too, so you guys know my role up here. Professor Weber's role in the community speaks for itself. He's on ESPN and I'm not, so you can find all the things that he says out there. This is all public. I can share, otherwise I wouldn't, of course. But I'm the outside general counsel for the 1890 Initiative, which is Nebraska's NIL collective. So obviously I can't get into player-specific things tonight or any deal points or money that everyone wants to ask me about. But happy to shed light on the industry and kind of how this works in practice. Right, there are a lot of different stakeholders at the table when it comes to NIL. You have universities, conferences, NCAA, players, coaches, agents, attorneys, accountants. I don't know that doctors find their way in there other than when players get hurt, but I'm sure doctors are in there too. So I'm happy to share the perspective of an attorney representing collectives. And we represent others as well, but the one that we're kind of known for, I suppose, is our role at Nebraska. So yeah, happy to share some thoughts.
So I thought I would start just with two pretty important images. The first one there on your left is if you are a video game player, you will recognize that. That is EA Sports. They are bringing back college football behind their Madden series for the NFL, one of their best-selling video games. There was a couple of lawsuits in the late 2000s, early teens involving Sam Keller, former quarterback from Nebraska, Ed O'Bannon at UCLA, that sued the NCAA and the various universities, saying that there were antitrust violations, prohibiting them from getting paid. Now that we have NIL, college football is coming back. They just announced that they're going to pay all of the college athletes who opt in a $600 flat fee, plus each of them will receive a free digital copy of the game on the platform of their choice, right? So, and for a lot of them, they did a poll of the college athletes. I found this very interesting because initially that $600 figure came out and people thought, well, that's really, really undervalued based on what kind of value these athletes bring. But if you do the math and you start to multiply out how many thousands of college athletes are out there that are going to get paid that $600, you can see why they're getting paid considerably less than the NFL, especially since the NFL game outsells the college football game. But when they did a poll of the students, they found that the majority of the students would have done it for free. They just wanted to be in the game. That for them was a big deal. The other big key aspect about this game if you are going to be a featured athlete, you can get paid more. And so the $600 is just the flat fee for everyone to opt in. If you're going to be on the cover or if you're going to have any other additional promotional aspect, you're going to be able to negotiate a higher rate for that going forward. And then the other image that we have up there, I think you recognize that young woman who is pretty incredible with everything that she has done, Caitlin Clark. And I have her up there because I think when NIL was announced and authorized back in 2021, people thought that the Caitlin Clark model was going to be the model for NIL. People were going to sign with nationwide brands, Gatorade, Nike, Adidas, whatever it might be. They were going to endorse those products and they were going to get paid to do so. Well, I think we saw NIL was adopted in July 1, 2021, and shortly thereafter, collectives were born and flooded into the space. And so now we have these entities that are organized by individuals who in the past, I think we would have historically called them boosters, like these very wealthy donors who are pooling funds, and they're trying to figure out, well, how can we get to these funds to these college athletes? And so instead of what we thought would happen, at least what the NCAA thought would happen in terms of brand endorsements, it's turned into sort of this quasi pay-for-play. So you want to talk about that a little bit, Tyler,
Sure.
how that's developed?
Right. So the collectives really serve.
Sorry, I'm going to switch you out again.
Lord. Check. You guys hear me? Nope. Thanks, Ted.
Oh, yeah. Now it's on.
You guys hear me? There we go. You guys will wonder what's this guy saying. Yeah, so collectives exist, as you know, Dave mentioned, to help pull together funds and deals for players. Y'all are drawing testament, man. So these collectives in practice are the go-between between a team hopefully having some success and finding the right players and sourcing the kind of the big player contracts that are out there. But more often than not, they're, to today's point, they're not really there to source a one-off Gatorade deal or whatever. They're there to try to build a roster, and it's turned into this fascinating. You know, I suppose most of you enjoy sports. I always would be here, but it's turned into this kind of quasi like cap management, NFL, MLB, NBA hybrid thing where you know, it's this outside company. They're not part of the university. They're not really affiliated either. They're there because the boosters have decided we're going to pull funds together to create deals. But it's been an interesting dynamic where players are able to actually go find more deals out in the community because the collective's out, you know, facilitating those kinds of introductions. You know, there might be a small medical practice in Hastings or whatever that they would love to be involved in NIL. They don't know the players. They don't know how to do it. So they call the collective and they say, hey, we would like access to 3-year volleyball players or 3-year football players. How do we get them here? And so that the collectives really serve as that intermediary to help players get deals done.
Yeah, and I think initially, you know, people had no idea the valuation of these college athletes and what kind of NIL value they were going to have. And the NCAA was very worried. They wanted to have these guardrails that was going to tie NIL value to these sort of guardrails based on market value, which if you're trying to figure out market value, it's what the market will pay, right? And so you get these collectives fill in this void, and they're starting to do a lot of deals. And what you see and what you hear about, for the most part, are going to be deals in men's football, men's basketball, women's basketball, and then especially in a state like Nebraska, women's volleyball. The vast majority of college athletes, I think if you look at the average NIL deal, it's worth about $500 per year per athlete. All right, so the average athlete is not going to get a lot of money. They're not going to be paid at that very high level. And in fact, if you're looking at those non-revenue generating sports, if you're thinking about your Olympic type of sports, oftentimes those NIL deals are going to be merchandise only. And so they're being pre-merchandise in exchange for a social media post. There are these third-party entities that have popped up, and they've tried to be a market maker. They tried to bring together individuals looking to hire athletes and say, you know, come visit one of our events, or do an autograph session, or even do a lesson for X sport for $50 or $100. And it really hasn't gone very far in terms of what's out there. For the most part, the money pouring into the athletes' pockets has been coming from collectives, far and away. And it's very much not the system that we envisioned. So, as you can see, July 1st, 2021, that's when this all really kicked into play. And since then, we've had a lot of issues and a lot of questions about money in college sports. And I think you probably heard the athletes are always complaining, why can coaches leave if the athletes can't, right? Coaches' contracts now are getting up into the 8 figures on an annual basis. It's very difficult to justify it to a college athlete why they shouldn't be making any money when they see a coach making $8, $9, $10 million a year, and rightfully so, right? And then you look at the size of the TV deals. March Madness brings in over $1 billion a year on the men's side, and the women's side has shot in value tremendously this year in terms of the TV rights for their tournament. And now we talk about the college football playoff system. To the extent that March Madness is financially successful, the CFP is estimated to be multiples more successful to the bottom line of universities. So there's all of this money in college athletics, right? And I think you've seen the public tide turn. When I started teaching sports law, I think it was 2009, the first time I taught it, I polled my students and I asked, how many do you think college athletes should be amateurs versus professionals? And I want to say it was between 85 and 90% that they should be amateurs, right? They should play for the name on the front of the shirt, not the name on the back. Now when I poll my students, it's the opposite. It's 95% plus thinking that these college athletes should get paid. And I think it's in large part due to the sheer volume of the dollars in the industry. So there, I know it's going to be tough to read. I tried to make it as large as I could. Those are the top 25 college athletic departments in terms of revenue. So you can see right there, number one, the Ohio State. Their revenue exceeds expenses at roughly $26 million. By the time you get down to number 25, this is the 25th most successful athletic department in the country, we see a loss, an operating loss. And so for the rest of the 200 or so Division I football programs, 300 some Division I basketball programs, all the Division II and Division III programs, they're losing money, these athletic departments. And that's taking into account all the TV dollars that are already flowing in to their pockets. So that's something we'll talk about as we go forward. If you're trying to balance budgets going forward, you just Google University of Arizona and budget deficit. Right now, they're $30 million in the red. 2 years ago, they were $50 million in the red. Who's paying off that deficit? The academic side of the university, subsidizing athletes. And so this is something we don't always hear very much about. It's always, let's talk about profit sharing for the players. Let's talk about how to get more money into their pockets, which is, it's great for the players who are bringing that value. And for the longest time, especially those players in the revenue generating sports, they've been creating all the value with zero of the benefit coming to them, but they've also been subsidizing all the other sports. And so as we start to see that money flow into their pockets, the revenue generating sports, I think we're going to see some similar cuts in other directions. All right, so that's just kind of the state of affairs. We'll touch back on that point as we get towards the end. But let's go to just a standard NIL deal. So Tyler, can you walk us through from birth to death, how does an NIL deal come into being?
Should we talk about it from the player's perspective or the
Let's go from the player's perspective.
Yeah, so, insert a name of a very well-known player that you can imagine. Might get a call from the collective because they say, hey, we found this deal for you. They're willing to pay the collective, $300,000 this year. But to today's point, there are certain obligations that we expect of you in exchange for this $300,000 that will pay over the course of the season. It might be autograph signings, it might be private dinners with the shareholders or kind of stakeholders of that particular company, attending events and all sorts of things. You can imagine the pretty long laundry list to get to $300,000 of value. So the player in that situation would have already been under a contract with the collective. So the collective has the exclusive right generally to go out and market these, or try to source these deals on behalf of players. So the collective is out there, going out to its owner base and all of their respective companies and trying to go source these deals for the players. And then the players, once they're under contract and the agency effectively of the collective represents them, they just, as these deals come up, they sign up for more and more obligations. Certain of these players have their own representation. They either have agents or they have lawyers. And so there's, pick a political topic, right? If the NRA was going to come put a bunch of money in NIL, you can imagine some kids would not want to do that. But we're running into those situations in real time where, maybe their uncle has a car dealership. And so, if Woodhouse wants to come across and give them a lease and say, well, we'll give you the car, we want you to go promote us. Well, they're like, hey, I'm kind of conflicted out here. So it's an interesting dynamic on the player side because they have some rights here that, historically they had no access to this money anyways, but they have, a team around them to go make informed decisions as to who am I going to do deals with to build my brand, build my reputation.
So one thing I think that people generally don't know is how does the collective get involved? Like, what's the first step? How do these players and collectives get connected? Because we oftentimes see, and we'll talk about the transfer portal in a second, that's a big issue where players are trying to figure out whether or not they have free agency while they're college athletes. So how do the collectives get matched up with these, especially when they're sort of prospective,
Sure.
which now is okay as of last week?
Yeah, that's a new rule as of 24 hours. Excuse me. Yeah, so players talk, right? It's like all of us at work. We all have our friends at work that we talk about things with, and your friends out in the community that you say, hey, you really should come work at our shop. Athletes are no different. They are recruiting each other like crazy. That's kind of number one in terms of how our players finding their way to the collectives is because the collective is representing their friends. Beyond that, to today's point, historically, in this very old industry of NIL, the players were not to, or the prospective players were not to be courted by the collectives until they were on campus, right? The whole idea was you cannot induce an athlete to come play at your school, which of course, and you can get into that case a little bit. That is exactly what the point of NIL is to induce kids to come play for school. So it was a very bizarre rule and construct, and now the courts are dealing with it in real time. We're dealing with a world now where I think what will happen is collectives will be involved earlier and more often with players. That's just a forecast that's not happening today, but I think to remain competitive in this industry, you have to adopt at lightning speed, and every single collective has the same mandate, let's go win championships. So I think you're going to have collectives dealing with players and with agents at an earlier stage than they would have historically, which would have been, waiting until they actually get on campus.
So what we see, and Tyler's absolutely right, we lived in this weird dichotomy where NIL was available to players, and it was there to get them paid, but yet the NCAA was maintaining this position that it's not pay-for-play, and it's not to induce, when everybody knows that that's what it was being used for. And we'll talk a little bit about how the NCAA's own legal positions have really hamstrung it and brought about almost all of what we're seeing nowadays legally. But what we start to see now are college athletes who are much more sophisticated, who potentially have the advice of counsel or an agent, that are going through these NIL deals. So Tyler, how often do you see a college athlete, especially one coming right out of high school, who already has an agent?
For the folks that are the 4-star, 5-star recruits, almost without exception have an agent. And whether it's an agent or their dad's uncle's cousin's friend who plays the role of agent, they have someone at the table trying to advise them. And really, I mean, it is to the player's benefit. They should have that representation because I'm biased, I suppose, for my primary client in this space, but the way that, and this is all public, so I can share this too, this is 1890's entire pitch to players. A lot of these collectives, they do exist as a business, right? They're trying to make some money. Maybe they take 10% from their kids, deal that they can source to pay for their operating expenses, right? They have a whole team to go support to build out this organization. And so, if a kid is going to come into the 1890 structure, the way that they work is that it's intended to be a revenue neutral operation. So $100,000 comes to the door, $100,000 finds the players, right? That's not true at all these collectives. So for the kids that do not have representation, they don't have a lawyer or agent at the table, they can find themselves in some really strange deals. I mean, there are some players, was it Miami or Florida? There was a really well-known or just a high-profile recruit that was I think the defensive lineman. It basically signed his life away. I mean, he signed it was basically a promise to pay 30% of his future NFL earnings back to this agency because they paid him.
So he earned nearly $500,000 from the NIL deal, but with his first NFL contract, he was already in the red on that deal. Right? The entity that had funded that in exchange for a percentage of his earnings was already profitable just with the first NFL contract because he didn't have representation.
Yeah, it's very predatory at this stage because it's such a new industry, and people are playing the role of sports agent when they really have no business doing that. So players need to have representation.
And so I think what you've heard in this space, and it's a cliche, but everyone talks about it, how NIL is sort of the Wild West, right? Where anything goes until it doesn't. And I think you've seen very few enforcement actions until recently when the NCAA announced that it was looking into Tennessee and what Tennessee may have done to violate some NCAA rules. And that's important because Tennessee was already on probation. And so thus far in the history of the NCAA, only one program, SMU, has ever received a death penalty where they had to shut down a sport for more than a season. And that penalty was so severe that the NCAA has been loath and has refused to impose it on any other schools, even in really heinous circumstances, like with the Penn State Jerry Sandusky scandal, right? That even in that type of case, they didn't go that far. So the NCAA, they don't have this huge enforcement mechanism that's allowing them to address this. They start to investigate. Tennessee says, well, we're going to file suit against you. Tennessee, joined by Virginia, they bring a lawsuit against the NCAA on antitrust grounds. And that was then where there was an injunction that was granted just last week. So we start to see these issues arise where the NCAA knows that players are get paid. They know that it's inducement. They know it's for recruitment. And they know that they can't enforce their own rules. And that's really where we are. And that's why there's so many problems with where we're heading. Just a week or two ago, I don't know if you saw the news that the NCAA issued a policy memorandum about how many cookies or whether or not athletes could have treats in their hotel rooms on official visits. And they said, the NCAA came out and said, well, you can't have them in the room, but you can only have them in the lobby. That kind of position is why everybody's upset with the NCAA right now. Because here they are fighting over literally cookies when we're talking about millions and millions of dollars that are at risk. And then that just brings us now to the transfer portal. So with this Tennessee ruling, collectives can go out and contact any athletes now, whether or not they are recruits, whether they're in high school, if they're in the portal, maybe even if they're not in the portal. So you can see some of that attempt to bring them on over. So as a collective, Tyler, how do you navigate that space when you're trying to maybe look at not high school athletes coming in, but potential transfer targets?
Yeah, I mean, or the seat that I'm in, I see it more on the other end where they're terrified that they're going to lose a recruit to the portal. Because like I mentioned, the athletes are talking school to school, and sometimes schools are reaching out when they're not supposed to be, or they have representatives that are reaching out and trying to tamper. So the seat that I'm in, I see more of a moment where fair market value, as Dave mentioned, is determined by whatever someone's going to pay you for in the space. And we both hear about it all the time. There are students that will leave for a $5,000, $10,000 bonus. It's no different than an employee in any of our businesses. If you're getting $20,000 at this school, but this other school is going to pay you $30,000, what are you going to do? So it's for us, it's a defensive effort to try to stay on top of our players being taken care of. Do they feel like that they are getting enough deals? Do they feel like their value is being represented by the deals that they have?
And so that's a great point. So I have a 21-year-old and an 18-year-old, and I got to say, when we're looking at colleges, as much as I wanted them to tell them to follow their hearts and go to their dream school, I didn't. Right? I said, well, let's look at the financial aid packages. Let's make our decisions based on what kind of is out there. I am not in private practice. So all of you in private practice, I'm jealous, right? But we made our decision based upon the money. And so for the NCAA, I think to come out and say, well, athletes shouldn't be making their decisions based on money. It's not only naive, it's disingenuous, because that's what everyone is doing as they're going through that college search process.
Let me tell you one funny story too on the Nebraska front that is, again, this is public, so it's fine. The way that they're handling the market research, of figuring out what are players worth, you guys will all know this. They have guys and gals on campus that are part of the operation, right? They help drive kids to and from the airport or take them to campus or whatever it is. The way that they are figuring out whatever the competition is that they're encouraging the driver to ask them what they're, basically, they're like 1 year older than these kids. So basically, get them to gloat to you, get them to be proud about their other offers. And so meanwhile, Sarah's driving the car and, she's sitting there, okay, Kansas State's paying $30K. Syracuse is going to pay $40K. And so they just open up like a book to say, here are all my offers, because they love to, have that position. And so it's been interesting for us to see in real time kind of players' values. And then you can tell, of course, when some of the players are big fishing, and it's like, no, you're not going to get 200 grand. If we know that Kansas State doesn't dole out that kind of cash. Well,
and then with some of those deals, you immediately see some of the problems facing the players. If they're going to go hire an agent, and let's say they pay somewhere between 10 and 20%, if they're getting, let's say, $50,000, right? 10% of that that's a big chunk for these athletes to give up. And so some of them are thinking, well, I'll just kind of go down my own path here and skip this counsel. And then you have them in the backseat talking to the drivers, just showing their entire poker hand, right? But this is part of what the NCAA is trying to avoid, this free market opportunity. And this is what the courts are trying to enforce, more robust market information. So let's talk a little bit about some of the recent cases. Okay, so this is the one I mentioned. So Tennessee, under the gun, via the NCAA, has the Attorney General file a lawsuit saying that it's a violation of antitrust laws for the NCAA to impose limitations in the marketplace, the NIL marketplace, that would affect the valuation of the athletes. And this came up for first a TRO, temporary restraining order, and then that was denied, but then they moved to that preliminary injunction stage. And in order to prevail on a preliminary injunction stage, you need to show that there's a high likelihood of success, right, and irreparable harm. And initially what the NCAA had been arguing was, well, there's not going to be irreparable harm because this has been our rule for decades, right? At the most, all we're talking about is money. Money is damages. We can make them whole going forward. But Tennessee made some really clever arguments. And I think it's important to note in this case, Tennessee has its own law in the books that mirrored NCAA policies. So the Attorney General of Tennessee was arguing that the NCAA policy violated the Sherman Act, knowing that Tennessee's law was the exact same. So how then are they able to prevail and get a preliminary injunction? Well, they moved it from their point of view of the state to the point of view of the athletes. And they said these college athletes have a very limited shelf life, and they only have so many opportunities that they're going to be able to go out and strike these NIL-related deals. And as a result of this improper restraint, we have no idea what the market is for NIL value. Now, right now, we have some athletes, you might have some in the low six figures, the occasional one in the seven figures, and every now and then you'll hear about an SEC quarterback at sort of a stratospheric level. But what the court said is we have no idea what the value of NIL, because the market has been so manipulated. These players can't even have a good, fair sense of what their own value is. So as a result, the court says the NCAA is enjoined, they're prohibited from enforcing their rules with respect to third parties and name, image, and likeness deals. So those third parties are boosters and collectives. So that was the decision last week that now lit off the firestorm, where collectives are really able to go forcibly into that marketplace, because before this, they couldn't speak with what are called PSAs, prospective student athletes. They were only supposed to be speaking NIL with athletes that had already committed to a particular school or had already come onto campus and started classes. Well, now the gloves come off, and they can start approaching these PSAs, prospective student athletes, and start offering them more and more and more and more. And as Tyler pointed out, what's going to happen? A market is very quickly going to develop, and we're going to have a really good sense of what the valuation is for some of these athletes. All right. And so that's how it goes with perspectives. Now, a couple of things are important. So first of all, that injunction didn't cover the whole country. Then the NCAA came out and said, we are not going to enforce our rules regarding third parties, at least while the injunction is in place. So for the time being, collectives have more or less free reign. That's not necessarily going to be the case going forward. And then we're going to want to see what is going to be the issue going forward as we start to talk about things like tampering. Tampering would be when either a collective, or even worse, a coach or a member of the athletic department goes and contacts a student who's on a roster at a different university to try to induce them to come to their school. Now, you may have noticed over the last couple of transfer portals that there are a fair number of deals where the athlete hits the portal and then immediately announces that they're going to a different school and signing with a collective. Tyler, is that possible to do in a span of a couple hours, or may there have been contact beforehand? And not for 1890, right. But for just general collectives. What do you think has been happening?
Yeah, well, I think we all know the answer there. It's it's fascinating to watch it play out in real time, because I'll get a call saying, hey, we didn't know that, for example, an assistant coach at name of competitive school just called our guy. What do we do? And so, like I said, we're always on the defensive about the way the portal works, and trying to stay ahead of that. And collegiate relations is a huge key to success for a collective, success of the program. And it's going to become more and more prevalent now.
100% agree. When I work with collectives, I used to reach out to them and we'd have conversations maybe every month or every other month or so. And now it's to the point where we're almost on daily communication, just because so much is changing so quickly. And I'll say, for the most part, most collectives, they want to do it right. They want to make sure that they're following the rules, but they also want to make sure that they're not losing out on the athletes. Because if I had a nickel for every time I heard, but X school is doing this, but Y school is doing that, and Z school is doing that, right? There's a lot of at least perception that other schools are, if not breaking, at least really bending some of these rules. And I don't think it's limited to the collectives either. I heard of a SEC head coach, I won't even say the sport because that might make it identifiable, who chartered a jet, went to a different university to speak to a student athlete at that university to offer them collective money. All of those are violations, by the way, right? And I'm hearing about this second, third hand. So if I'm hearing about it, other people are hearing about this as well. But I think that's the state of affairs. So these collectives are thinking we want to do things the right way, but the NCAA is trying to impose this framework that's just not realistic. It's not going to allow us to do that. And so the result are these lawsuits, right? More and more lawsuits. So the next one, I mentioned this earlier. This was earlier today. The Dartmouth men's basketball team voted 13-2. So out of the 15 athletes, 13 voted to unionize. That means that Dartmouth now has to negotiate with the members of that basketball team, because if they fail to do so, well, that's an unfair labor practice under the National Labor Relations Act. So right away now, we see these college athletes, at least by the National Labor Relations Board, the NLRB, being treated as employees. And it's not a surprise, this result at all, because the general counsel for the NLRB had already come out and said that I believe that these athletes are in fact employees. If you look at the level of control that's imposed over them, the different requirements, the level and the quantity of work that they're doing, they meet all of these various indicia of employee status. So that's why the case, I think, came out the way it did. Importantly, from this case, I think, is that the school is Dartmouth. It's an Ivy League school. They do not give athletic scholarships. So none of the athletes that were on that team voting had athletic scholarships. And Dartmouth men's basketball team loses money. So here we have a program where it's non-scholarship athletes at a non-revenue generating program being deemed to be employees, right? There's another NLRB matter going on at the same time. It's USC. It's for their men's football, basketball, and women's basketball team. To the extent that Dartmouth prevailed, USC is going to be practically a slam dunk, right? Because there you do see this high-level athletic scholarship, high NIL value, and high profitability markers. And so we see now probably 2 schools already heading down this path. NLRA does not apply to public employers. So a decade or so ago, Northwestern University's football team tried to do the same thing. At that time, the NLRB declined to exercise jurisdiction because they said, well, Northwestern was the only private school in the Big Ten. We don't want to upset the entire apple cart going forward. So for labor stability purposes, we're going to decline to hear this case. Well, here we are in 2024, and the approach is going exactly the opposite direction. But at least for the NLRB matters, this is going to be more limited in scope, right? Private employers. But there is another case that's out there. Johnson versus the NCAA. It's out in the Third Circuit. And this case involves, I'm going to get it right here. So it's a claim by a football player from Villanova, a swimmer from Fordham, a tennis player from Sacred Heart, a soccer player from Cornell, and a tennis player from Lafayette College. They are suing the NCAA under the Fair Labor Standards Act and the applicable state laws in their jurisdiction for essentially minimum wage. Now, those athletes are, for the most part, not on revenue-generating teams in necessarily Power 4, 5 conferences. If they win, now we look at a nationwide flip from amateur to professional. And if you look at how many hours every athlete is working on campus, right, across the football team, basketball team, volleyball, soccer, track, swimming, etc., and you multiply that out by the minimum wage, you're going to see a pretty hefty wage bill facing these universities, right? And all that television money, well, they've already spent it, right? So it's not like it's just sitting there in a pot where they can redistribute this, right? So if I'm thinking, and I'm advising people, when I say the case to watch out for, it's not those NLRB ones, right? It's this one. And then there are two other ones. I just want to mention quickly before we talk about some of the other big issues going on. So there's the case out in the Northern District of California, House versus the NCAA. So this case was brought by the attorneys that won the Alston decision, that Supreme Court 9-0 decision, also from 2021, which opened the door towards NIL. It actually did not have anything to do with NIL. But once NCAA lost 9-0, they saw the writing on the wall. So House is a companion piece, and it says, well, the NCAA, you improperly excluded athletes from the right to earn money from their NIL for all times prior to July 1st, 2021. So we're going to sue you for the entire look-back period, and they're claiming $1.4 billion in damages. And that amount can be trebled under the statute. So now we're talking $4.2 billion in damages. And while the NCAA has a nice little building in Indianapolis and $1 billion coming in each year, not sitting around on $4 billion of surplus money, right? This is a potential NCAA killer, right? Looking at realistically what could happen. So this is House. It's actually in front of the same judge who decided the O'Bannon case and the Alston case at the lower level. So if you're the NCAA, I don't think that fills your heart with warmth and joy because you've already lost in front of her twice. And then we now have the NCAA versus Carter. And this was also filed by the same lawyers in front of a different judge now. But here what they're saying is the NCAA screwed up because they prevented universities from being able to pay their athletes, right? So the prior two cases there were about NIL, just in the marketplace. This case specifically looks at pay per play, whether or not universities should be and should have been paying their athletes. And there was a great quote a week ago or so, and there was a commentator that was asked about why does the NCAA keep getting sued and losing? And they said, well, if they would stop violating antitrust law, they'd stop losing, right? And that's really the rub right now. So the NCAA, all the way back to the 80s, when they lost their first case involving the University of Oklahoma and wanted to be on television more than twice a year, they've taken really intransigent positions and really indefensible positions, especially now as we start to see how antitrust law is being applied to their industry. So let's think a little bit downstream, Tyler. So now that we are clearly in the NIL era, what do you think might happen in the near term, midterm with actual pay for play? And how would collectives see a move to that kind of model?
Well, we're dealing with this in real time. It's kind of the flip side of the coin. I said earlier, when it's great for players to have agents. I mean, they're asking for pay for play already. They want to know that, hey, if we win the Heisman and I'm all conference, pick your accolade. I want to know that my salary goes from X to Y. And so it's something that without really having the framework to provide for that the players are asking for it. So I think that we're directionally heading there, whether we want to or not.
So, and I think you're absolutely right. Where we're heading might not be where the NCAA wants us to head, but they're getting pulled in that direction. I have a really good friend that works at the NCAA, and he's trying to do the right thing. They're trying to do what they think is the right thing. And the NCAA, they don't really call the shots. The NCAA is just a member-driven organization. All the rules have been adopted by every university here in the country. Those are the ones that are in charge of it going forward. And the NCAA is sick and tired of these lawsuits. They're spending between $40 and $60 million a year in legal fees. So for the lawyers in the room, you're thinking, yeah, nice day at the office, right? But for everybody else, you're thinking that's a lot of money. So one thing that does get kicked around every now and then is, do you think college sports might break away or break off from the NCAA?
Yeah. Whoever said that, I agree. I think the SEC and Big Ten are positioning themselves to examine that. I might be misremembering this, but I think they put together kind of a workforce or joint.
Right. I would call those two conferences Fox and ESPN, but it's the same thing.
All first team Fox was a different.
So, but I think this is where the NCAA does get short shrift. If they offload this, or if the teams want to break away, somebody's got to run it. Someone has to take charge of that. Someone has to be the face of it and be willing to get sued over it. And so you're going to have an entity that's willing to step up and do that. Now, that model is probably going to be much more professional in nature than what we see currently with college sports. And that means the gamut, right? Like Dartmouth, unionization, collective bargaining. And we're going to see, just like with the NFL, Major League Baseball, and NBA, they have a collective bargaining agreement where everything gets ironed out, hammered out, and that's where you are going forward. But that means that college sports are now college professional sports, right? And so we'll see kind of how the market might or might not respond to that. So if we're talking about college professional sports, what kind of issues do you think might be more difficult at the collegiate level than the pure professional level if we move into that model?
Well, I think the one right now that's just as a total unspoken, no one actually knows the right answer is, should there be a cap, right? Should there be, like the NFL, right? Every team can only spend $170 million or whatever it is every season to go win. Right now, there is no cap. Right, and this is just a kind of among practitioners. Like I said, I don't know really who knows this answer, but to build a competitive football team, you need $5 to $10 million a season. I mean, that's not to go win the college football playoff. That's just to be competitive. It's crazy. The world has evolved faster than we ever imagined, and there's not a lot of guidance there. So I think that's one example of how this will become professional. And I think there'll probably be with the Lionel Messi type contracts out there someday, where he gets, as part of his deal when he joined Miami, he got a portion of the team. He gets some of the spread of the increase in revenue that they generate from TV. There's an being there. I think all of that's going to be baked into the CBA structure with the players that are part of the Fox and SEC or Fox and ESPN conferences.
Yeah, and I agree 100%. Players, they're savvier. They want equity. They don't want to just be an employee. And I think when we look back on this moment in a couple of years, we're going to see probably that right now we're at the height of the NIL era. I don't know that it's going to get any better for college athletes, because what they have is essentially unrestricted free agency. The pros don't get that, right? Pros in their CBA, they have those rookie deals that keep them there. Then some have guaranteed, some don't have guaranteed money. They have different issues about when they might get traded or not. Right now, college athletes are getting all the benefits and have all the freedom that go along with it. So you talk about a salary cap. Well, I think about how our professional teams get their players. They draft them. Are we going to tell 18 and 19-year-olds, oh, congratulations, you're going to this university, you've been drafted? right? That's how we deal with competitive balance, with the salary cap and with the draft. And I don't think anyone's really thought about that kind of issue going forward. Another issue that I deal with on a daily basis is I deal a lot with international college athletes. So international college athletes, they're here on student visas. That means they're not entitled to work in the United States other than as set forth in our regulations. And currently our regulations do not cover playing sports as one of the acceptable means of working either on campus or the very limited off-campus exceptions. And so the thing that blew my mind today, that this Dartmouth vote was 13-2, they have 4 international athletes. That means at least 2 of them voted in favor of this, a move which could jeopardize their student visas, right? No one's put a solution in place because when the student visa was created, this problem never existed. It couldn't have existed, right? So we're starting to see these unintended consequences. Well, what about bringing athletes on board as employees? Are they going to have the benefits? What kind of health insurance premiums might they have? What about participating in our 403B, the equivalent, the nonprofit equivalent of a 401k plan? Are they going to have super exceptions available to them to max out more than the rest of the employees? All of these issues, these just standard employment issues, that haven't really been grappled with yet. I think we're only going to start to see more and more of them come out as we're going forward. All right. So a little while ago, I saw in the news that a hedge fund manager said that if he could buy the University of Michigan football team, it would be worth over $1 billion. Thoughts, Towel?
Seems a little light. No, that's remarkable. I think what's the lowest value of an NFL team? 2 or 3 billion, something like that.
It's got to be around there.
So I mean that speaks to the professionalization of college pro sports, like you said.
And that opens up all kinds of questions. Who's going to own these teams? Right? Are we going to have a situation where hedge funds are going to come in and license naming rights from universities? That actually might not be a horrible deal for the universities. They can just get royalties. They can offload all of the compliance issues. And then the money just kind of comes in. They can license and lease out those facilities going forward. But is that what the fans want? I mean, are you going to feel like you're cheering for your University of Nebraska brought to you by X corporation, right? Or X or Y hedge fund? Those kinds of discussions, I don't know that we're in a mature enough place market-wise to really know what's going to go on with that. But man, change is coming, right? The dollars are there, but I just don't think that they're going to be as large as some others think that they're going to be. All right, so while we were talking at the dinner table, we mentioned a little bit about Division II and Division III. So far, everything that we've been talking about has been Division I athletics. How do you see any of this impacting Division II and Division III sports?
Well, I think we're seeing it play out in real time with Division II, at least, and I think it'll affect Division III as well. With the fact that there is no salary cap, right? But the fact that teams have, in football as an example, 85 scholarships to give out at the Division I level. If there's no salary cap and they can go get the best players they can get, what NIL has turned into is that it allows for them to go build a roster of way more than 85 guys. Some of these schools are basically using NIL to say, all right, well, yeah, I think there was a school recently that got a 3-star commit that had offers all over the place, but he chose to be a walk-on at some other school because he was going to get paid, 25, 30 grand or whatever. So he's going to be able to pay for his school. And so it's turned into this new dynamic to allow for an increased roster size, at least in football as the example here. And as that affects the lower, the even kind of group of 5 type of Division I programs, it creeps into every level. I mean, Division II and Division III programs are hurting right now because guys or gals that they thought that they would be able to get it historically, they can't get anymore because it's too expensive.
And I think one of the things that, piggybacking on that with that expense, one of the things that's not being discussed at all, or at least not enough right now, is as I'm going through and I'm reading all these cases and decisions, I'm trying to find limiting principles that would limit these decisions to Division I athletics. And the more I look, the more I see that there aren't any. And so these rulings are going to apply to Division I athletes because they work this many hours, or this type of control imposed on them by the coaches, or their schedule. Well, why aren't they then employees at the Division II level, Division III level, high school, right? And so you start to see if we make this this move towards classifying these individuals as employees. I went to a Division III college, and I gotta say, I loved going to the football games, basketball games, the sporting events. The quality wasn't what I get to enjoy on a nightly basis down at the CHI, right, in terms of basketball. But heck, it was a lot of fun. And are we gonna start to jeopardize some of those traditional college experiences because we're gonna start to limit, one, how many sports are gonna be around? Schools are gonna have to make tough budgetary decisions, right? And they're gonna have to probably engage in some cuts. How does that then affect the rest of that model going forward? That's where I think we have not yet seen enough of a discussion. So I want to leave just a couple minutes for questions. So one last question for you, Tyler. Looking into your crystal ball, what's the future of college athletics?
1 minute to answer. No, I think the most imminent challenge, and we've alluded to it here, is the SEC Big Ten dilemma. I think whatever path that issue proceeds down is going to shape everything. Washington State and Oregon State are basically up and out in the Pac-12, and as these this kind of consolidation of power occurs at the top, every other school that's just not quite there, they're going to feel the pain. And to today's point, as you go further downstream to Division II and III and so on, I fear that there's not actually going to be an opportunity to play sports at those schools because it's not going to make sense financially, particularly if any of these employment-related issues arise and suddenly you're paying salaries for your 120-man Division III football team. So I'm hopeful that there's going to be a workaround here to allow for NIL to have some structure to it that it lacks right now, to create a salary cap and have there be transparency for players, and we'll see where the courts fall on these employment issues. But I think to answer your question more succinctly, I think the SEC Big Ten split that almost feels inevitable at this point is going to dramatically shape college sports.
And I think, one of my worries is Olympic sports, right? So many of us, when we watch the Olympics, we all tune in for the medal count at the end, right? We just want to see how many medals and whether or not we're on top or second or third, where it might be. College sports has been a minor league for all of these Olympic level sports. And if those go away, well, someone will have to pick up the slack, and that's a lot of money, right? So that's a fair number of things there. So hopefully we left you with a lot to think about. You guys have any questions before we wrap up?
The medical issues involved. As an employer, we pay workman's comp, pay into people's health insurance. With sports injuries and some of these athletes who have lifelong disabilities suffer their injuries. I haven't discussed that, being that whole area, not so much in terms of this, but in terms of college sports and the fact that if you're going to treat somebody not as an amateur, they're not just out there playing for fun. And all of a sudden there's an issue of workman's comp, healthcare involved.
We're seeing this
related injury.
Right. So today's position would be that I'm sure it all feels this way, is that the players are independent contractors. They're not making health insurance premium payments up for these players. But we're seeing this in real time with a few player negotiations, particularly the folks that have a little bit more kind of value behind their name. They're going out and obtaining insurance on their own behalf to protect against injuries. And I'm not close enough personally to understand kind of how those policies work, but you can imagine all this like sports, pick your favorite player's injury. Is it insurable? If he's out for 2 weeks because of a sprained ankle, is that an event that requires some sort of payout, or is it just upon termination or a career-ending injury, right? So it's a new area. It's really gray. And something that I don't personally have enough visibility into, but I know it's something that players and agents are really closely looking at.
And just quickly on that, one thing the NCAA has done quite well over the last couple of years is expand insurance coverage and offerings for the student athletes. And so they have longer term insurance that's going to cover them even post university playing time. And then I think we'll get to something we might see in the professional level where under some of the professional CBAs, they say, well, we're going to opt out of essentially workman's comp, and we're going to cover this privately. And at the professional levels, there's that income there that can do that. Yeah.
So do most major colleges have one collective or multiple collectives? And are there written contracts with every player? And are they 1-year contracts or multiple-year contracts?
Depends on who's asking. The agents want to make every year a 4-year deal. That's usually not how it goes. It's usually, at least in my experience, it's usually a 1-year player contract. And honestly, with a lot of termination rights, right? If you're off the team, if you get kicked out of school, if you get a DUI, there's a whole laundry list of termination provisions that can cut the deal short. But also, it's to the player's benefit too, right? We're in the middle of doing one of these right now where a player wants a multi-year deal, and it's like, well, I certainly appreciate your position that your value is this, but we think it's X, not Y. And so when it's a 1-year deal, obviously, knowing that we're talking about an unrestricted free agency world, in year 2, if you're really worth Y instead of X, like we're going to have to account for that in a new deal, and if not, you're going to leave. So the fact there's a 1-year deal, I think, keeps both parties honest. And then to your first question, I think the norm is probably not one collective per like major, kind of Power 5 type school. But what I've seen is some of these schools will make a different collective for a particular niche, right? Like there's one I heard about that has a bowling team collective, right? And it was from a guy that made it in life, and he was on the bowling team in 1982 and wanted to make sure the bowling team had their money. And so that bowling team's doing all right. So yeah, I'm not sure what you're saying.
And I was saying, and initially, some schools had multiple. I know a lot of them were half of them were nonprofit, and half of them were the for-profit entities. The non-profits have gone away because of an IRS ruling on that. But there still are a fair number of schools that have multiple collectives, oftentimes divided by sport. Yeah.
I think these NIL issues are going to affect club sports, particularly in the context of a D1 school with a club sport like Nebraska, like in hockey.
I wouldn't be surprised to see a lot more club sports, because if the university can then say it's a club sport funded by students, that lets them offer those sports at zero cost. And so that would actually be one of my predictions for what will happen, is there'll be a greater number of club sports to the extent that they continue to offer some of those non-revenue generating sports. I think we have time for maybe one more.
So I'm going to kind of dovetail on the physical health piece. I worry a lot about the mental health of what's happening to young people when they're faced with so many big decisions. Is there anything that it's being offered to them through their schools or in the NIL or insurance to help them with that? Because these are not decisions that are going to be made by an 18 or 19 and 20-year-old kid who's just coming into college. And that's my worry.
Do you want to take a quick
I think some collectives are really good at this, and what they do is they build an army of advisors, if you will, for the team. And so a team psychologist might come in one day, and a financial advisor might come in one day, an attorney might come in one day. For those organizations that have that infrastructure, I think your concern is being addressed. I think at the smaller schools, I would virtually guarantee that's not happening.
One thing I'm at, at the larger schools, there's usually an education component. So at Creighton, for example, we teach a summer course to our incoming student athletes, and it's going to cover a number of different components: legal issues, taxation issues, investment issues, and branding issues. How do they create their own brand and market that going forward? And the decisions that they're making aren't terribly different from a lot of decisions that 18 or 19-year-olds are making when they go into $60, $100, $200,000 with undergraduate debt. Now, fortunately for them, it's on the positive side of the ledger rather than the negative one. But especially at the major university level, you're going to see a lot of education offered. Now, that education is offered once those students are on campus, right, rather than when they're perspectives.
And for what it's worth, a lot of collectives make this a requirement. They say if you want us to be your collective and then go take care of you and source these deals, some of the quid pro quo is going to be, okay, you're going to talk to the attorney, talk to the advisor. You're going to have that guidance, because we don't want to be on ESPN for the wrong reasons, because our entire team didn't pay taxes this year. So there's a lot of incentive to make sure that they have a good team built around the players.
All right. Well, I think we're out of time, so thank you very much.
Thank you.